In this video, I will be explaining what you can expect during the trial phase of a criminal case, the pre-trial trial phase, that is. My name is Veronica. I am a criminal defense attorney here in Los Angeles, and I help people who have been arrested put their criminal cases behind them so that they can enjoy their lives and their freedom. And in this video, I'm going to be explaining what to expect after the information arraignment, which is part 4 of this video series, but before the trial. So if this is the first video you're watching in this series, I encourage you to go back and start from the first one, unless you've already been through that part of your case. And down below, you're going to see that there is a criminal case timeline you can actually download for free, or not even collecting email addresses or anything like that. And this is not marketing material. This is something that I made for my own clients a while back, and that I'm just providing to you and going through and explaining some of this stuff on video. After the information arraignment, there are going to be a series of check-in dates. So this is similar to before you ever had your preliminary hearing, and where there are these hearing dates set up, and you're like, what exactly is going to happen? What is the court going to hear exactly at that hearing date? And really what it is in general is a chance for your attorney to talk to the prosecutor, to make sure that if there's some missing discovery, for example, we have it. We always hope and we try to have it before the preliminary hearing, but sometimes maybe there's some piece of it we didn't need before the preliminary hearing and you're in jail. So do you want to sit there and wait for it, or you want to go forward? Many times people will want to just go forward and get it later. 995 motion, so that is something notable. That's something that can't happen in the pretrial phase. So at the end of the preliminary hearing, your defense attorney is always going to move to dismiss based on insufficiency of the evidence, saying that basically they didn't present a case, they didn't present enough. And the judge is almost always going to deny it. Sometimes for some charges, there's some element that just isn't there. For example, let's say it's a robbery case. Robbery is taking something by force or threat of force. And let's say that there's no showing of force or threat of force. Something was taken, but no force or threat of force. Okay, maybe that will get thrown out. But usually not. And in that case, so let's say that that was your case and the judge didn't throw it out, you would want to file a 995 motion, because that is where your attorney can file a written motion using the preliminary hearing transcript to back them up. Getting this new judge, it's going to be a different judge than the preliminary hearing judge in almost all cases, to really look at this, reconsider it, and consider dismissing those charges. Now, this is a good idea to file in most cases, because at minimum, if the DA is not going to give you what you want, and if you've made it this far, so far they have not given you what you want, right? You would have accepted it and the case would have been over. You're making them do more work. You're making them look at the case more closely, because they have to actually write out their arguments for why they think that they provided enough evidence at the preliminary hearing to show that the case should stay open. And by the way, in that 995 motion, you cannot bring in any new evidence. So if they forgot to present something at the preliminary hearing that they think would save them now, maybe they have a witness that could show force or threat of force in that robbery case, but nobody testified to it at the preliminary hearing, they can't bring it in. You can't bring in any new evidence either. But that's okay, because you don't need to show evidence. They are the ones with the burden of proof, not you. Sometimes judges will not allow you to, and this is more specific to Los Angeles County than other counties, sometimes judges will not allow you to get certain experts before the preliminary hearing. And in some other counties, like I know Orange, they're very stingy with experts and don't want to give them to us ever. But in LA County, if you were in the trial phase, you are much more likely to be able to get those experts. So let's say you need like a drug expert. Maybe the other party, or the alleged victim, was on drugs or something like that. You might want to get those experts appointed, and then you can use their reports either at trial or even to negotiate, to keep preparing your case, keep trying to change things in your case, to make sure that if the DA's pile of evidence or their case is over here and you started out over here, you want to get up as far as you can so that you gain some leverage here too. You're not begging them for a deal. You're showing them that, hey, you guys are going to spend so many resources on this case. Maybe your case isn't as good as you thought. And then you're always, your defense attorney should have an undertone of, and my client is a good guy who deserves a second chance because of X, Y, Z. So this, if your case is actually going to go to trial or it's being prepared for trial, you can expect multiple of these check-in dates. This can take a while sometimes. I always tell my clients in terms of waiving time, and there will be a separate video in this series that talks more about this, but if you're going to waive time, if you're out of custody, like unless you have some good reason not to waive time, if there's something that could benefit the defense for sure, even if it's marginal, you should probably waive the time. Why not? Speedy trial is for when you're in jail. If you're in jail though, you should not be waiving time and letting this process take a really, really long time unless it is to your benefit. So these things that I've mentioned are to your benefit. All of them, if it applies to your case, all of them do take time, but they are to your benefit. And I mean, there's some caveats to that. Sometimes a case the evidence is so strong against the defendant. Maybe they have surveillance video or something. And we know that eventually in that case, there's no way to get the video thrown out, which there probably isn't if it's surveillance video, then we know that probably the case is going to end up with why we're not rushing to trial, because we know we won't win the trial. So we need to make sure that we do every single thing possible to, again, make sure that if the DA's case is here, ours at least gets up here, and then hopefully whatever kind of deal we get is going to be a lot better for the client. And usually if we are in this trial stage, you show the DA, hey, I'm working on this case. I'm getting these experts appointed, I'm filing these motions. Usually the deal will get better. Not every single case. It depends on what the offer was from the very beginning. So anyway, I hope that you found this helpful. If you do have a criminal case in Los Angeles, feel free to book a consultation with me down below. You can find the link there, and you can also find my number there. Anybody else, if you have a question, feel free to leave a comment. And then don't forget, if this is useful to you, just go ahead and download this PDF so that you can have the whole criminal case timeline and have a much better idea of kind of what to expect in your case.